Howdy, my name is Brian Foley. I'm a criminal defense lawyer here in Conroe, Texas, and I represent folks who've been accused of crimes in Conroe, the Woodlands, Houston, and that general area. Today we're continuing our Rules of Evidence lecture series. We're on Rule 204. It's the last rule with regard to judicial notice, and it says that a judge can take judicial notice on its own motion, or what we call sua sponte, or at request of one of the parties, any of the laws of the state of Texas, agency rules, or county ordinances. And so the laws of the state of Texas are going to refer to things like things in the penal code, the code of criminal procedure, health and safety code, government code, things like that. Stuff that was written by the legislature in Austin. And agency rules are going to be things like the Department of Public Safety has certain rules. That's an agency of the government. And the trial court gets to take judicial notice of those things. County ordinances. So let me give you an example of a county ordinance. Montgomery County has a juvenile curfew ordinance that makes it a crime for a person under 17 years old to be out from 12:01 a.m. until 6 a.m. So if there was some kind of dispute about that, then the court could take judicial notice of that. So this rule is not super useful, but there it is. You can do it now. The old rule was that you had to get a certified copy of the law that you wanted to talk about and then offer that to the court, which was a real pain in the butt. And the lawyers got together and said, we don't want to do that anymore. We created Rule 204, passed it, and it's now the law in Texas. So I will say that the one thing this rule reminds me of is that every now and then lawyers can come together and make things easier for the practice of law, make it better. But lawyers are the most likely to hold on and be the last ones to change. There are still lawyers who use fax machines, and the Department of Public Safety actually forces you to use a fax machine still. Crazy, I know, in the year 2021, post-pandemic. You'll have these hearings and you'll be totally remote, like everything's done via Zoom, and yet you cannot communicate via email to a DPS prosecutor for, let's say, an ALR hearing. Madness in the state, but the government and the lawyers, then you put together a government lawyer, they're going to hold on to whatever was the way it was done before for as long as possible. So maybe there'll be some more good changes. This one took a long time, I guess. There'll be some more in the future. Good to hear from everybody today. If you are watching this on YouTube, as my favorite YouTuber says, punch that like button in the face and subscribe and share it on Facebook. Do whatever you can. Help us out here. Hope you've enjoyed the Rule of Evidence series. We're going to be moving on to some more rules in the future. Thanks very much.